Okay, welcome back. Welcome back, y'all. Welcome back to Legally Everywhere. You know what? We are legally looking into everything, right? We are everywhere looking into everything. And today, y'all, the Supreme Court issued a ruling against the Trump tariffs. And instead of us jumping all into these articles and these headlines, I figured we should just go ahead and read what they call the syllabus of the actual binding, right? Their ruling. I figured we should just go ahead and read the syllabus because that's basically the summary, right? So I'm gonna pull that up for you right now. Okay, and we are back. I have not a clue what happened while we were trying to go ahead and get y'all to the. Okay, I don't know what was happening there. But I know what we're going to do is and read this opinion, okay? So as that goes there, let me move this to the side so that I might also see y'all as you see me. Because we about to read this lovely article. Y'all up out here, which is hilarious. Okay. So as you can see, I went to the Supreme Court of Justice official website. You can see that right here, right? I went and pulled the actual opinion, and that is for this very specific court case, okay? So if you're very interested in the name, it's Learning Resources Incorporated versus Trump. This just came out today. This is a 170-page document. So you know what's not about to happen, right? I am not about to read 170 pages during this live, right? Folks don't generally have an attention span long enough for that. So I try to do what's engaging. So I'm just go ahead and read you the summary that they put together. These are not my words. These are not my opinions. What the syllabus of the Supreme Court. So I'm going to go ahead and highlight that. So we're going to go ahead and read through this. We're reading through the syllabus, right? So also, so that you might have this for your reference, this was argued November 5th of 2025, and they made this decision today. All right. So I hope this is big enough. Okay, y'all. The question presented is whether the International Emergency Economic Power Act, which is the IEEPA, authorized the president to impose tariffs. So then it says see section 9(1) statute 1626, right? Shortly after taking office, President Trump sought to address two foreign threats: the influx of illegal drugs from Canada, Mexico, and China. Presidential Proclamation number 10886, and then 90 Federal Reg 8327. Have another executive order. So this is executive order 1413, my apologies, 14193. And then it also references executive order 14194. There's another executive order, right? 14195 that are being referenced, right? And large and persistent trade deficits, right? So those are the two main things that they're talking about at this particular point. And then they reference another executive order, which is 14257. Okay, so for the point of reference, I'm going to just go and make it another color, y'all, so we can see these different executive orders that are being referenced. Because we did talk about the fact that at some point we was going to try to address things that happen with executive orders. So we see that's 3 right there. And then we have this 4th one right here. Okay. So the president determined that the drug influx had created, or rather it had, quote, created a public health crisis, end quote. And it talks about regulation right there. And that the trade deficit had, quote, led to the hollowing out, end quote, of the American manufacturing base, end quote, undermine critical supply chains, end quote. Okay. The president declared a national emergency as to both threats, deeming them, quote, unusual and extraordinary, end quote, and invoked his authority under the IEEPA, right? And we learned that the IEEPA is what? The International Emergency Economic Powers Act. Okay? That's in the paragraph 1, y'all. He imposed tariffs to deal with each threat, right? So he imposed tariffs to deal with each threat. They reference 2 threats. As to the drug trafficking, tariff imposed a 25% of duty on most Canadian and Mexican imports, and a 10% duty on most Chinese imports, right? As to the reciprocal tariffs, right? And some people might have seen that there was the image on the cover that showed that he had the reciprocal tariff little plaque thing. So the trade deficit, which, quote, reciprocal tariffs, the president imposed a duty on, quote, all imports from all trading partners of, going to the second page, at least 10%, with dozens of nations facing higher rates. So since imposing each set of tariffs, the president has issued reductions and other modifications. Okay. So with regards to those tariffs, there have been 3 things that have happened that they are noting. Pick this color for fun. Okay. I'm not having a steady hand today. Okay. So increases, reductions, and other modifications. The president has issued several increases, reductions, and other modifications to the sets of tariffs that they are referencing. Okay. Petitioners in learning resources and respondents in the BOS selections filed suits alleging that IEEPA does not authorize the reciprocal or drug trafficking tariffs, right? It does not authorize those 2 things, right? So the learning resource plaintiff, 2 small businesses, sued in the United States District Court for the District of Columbia. That court denied the government's motion to transfer the case to the United States Court of International Trade, which is the CIT, and granted the plaintiff's motion for a preliminary injunction, concluding that the IEEPA did not grant the president the power to impose tariffs. Okay. That's a mouthful, right? Okay. So let's go to the very next piece. The VOS sections plaintiff, right? So it's the second part. The VOS sections plaintiff, 5 small businesses and 12 states sued in the CIT. The court granted summary judgments for the plaintiffs, and the Federal Circuit, sitting in bank, affirmed in a relevant part, concluding that the IEEPA grants of authority to, quote, regulate, importation, end quote, did not authorize the challenge tariffs. So it's a couple things that are happening here. Let's also just mark some of the things that they are saying because, that is important. And I did say we would look at it. Did not challenge tariffs. Did not grant the power to, it's what the Supreme Court justice is saying, right? I didn't say it. Okay. So did not authorize the challenge tariffs, which, quote, are unbounded in scope, amount, and duration. Those are significant metrics when you're looking at something, right? The scope, the amount, the duration are unbounded in scope, amount, and duration. Okay. So the government filed a petition for certiorari in VOS sections, and the learning resources plaintiff filed a petition for certiorari before judgment. The court granted the petition and consolidated the cases. Okay, so just a quick, because I know this piece can sometimes be off-putting. This means like writ or an order for, there it is, a writ or order by which a higher court reviews a decision of a lower court. Okay, right? I always say I want stuff to be super accessible and don't just be trusting my little old ears. So we looked this word up. I'm going to just highlight it just this one time. It'll come up a couple more times. Point of reference. All right. So what happened? The court consolidated those cases. So they was two separate situations. They put them things together. Okay. So held, the IEEPA does not authorize the president to impose tariffs. The judgment in number 24-1287 is vacated and the case is remanded with instructions to dismiss for lack of jurisdiction. The judgment in number 25-250 is affirmed. Let's make this yellow. Okay. So, oh no. Oh no. Okay. So number 24-1287, right? And then we go to, I'm guessing, portion 784. I'm not going to pretend to this, but this is a citation, right? Specific one is vacated and remanded, right? 5-250-149 is affirmed, right? This one is vacated and this one is affirmed. The Chief Justice delivered the opinion of the court with respect to Part 1 and Part 2A1. So Article 1, Section 8 of the Constitution specifies that the Congress, quote, the Congress shall have powers to lay and collect taxes, duties, imposts, and excesses. The farmers recognize the unique importance of this taxing power, a power which very clearly includes the power to impose tariffs. And this is Gibson versus Auden. And they gave Congress alone access to the pockets of the people. The Federalists, well, this is another citation here, number 48, page 310, J. Madison. The farmers did not vest any part of the in the executive branch. Okay, so this sounds like a checks and balance part right here, right? The Congress has the power to lay and collect taxes, right? They're being very clear in what they are saying right there, right? And we are reading this together. Child, I don't know what I thought that was going to do. Okay, let's try this one more time. My hand is not moving straight, but y'all get it, right? They know the farmers did not vest any part of the taxing power in the executive branch. See Nicole versus Amis. See them put that there's these other places that you can look to support what they're saying as a point of reference. So the government thus concedes that the president enjoys no inherent authority to impose tariffs during peacetime. It instead relies exclusively on IEEPA to defend the challenged tariffs. It reads the words regulated or quote, regulate and quote, importation to effect a sweeping delegation of Congress's power to set tariffs policies, right? To set tariff policy, authorizing the president to impose tariffs duration on any product from any country. Okay. The Chief Justice, joined by Justice Gorsuch and Justice Barrett concluded in Part 2A2. The court has long expressed reluctance to read into ambiguous statutory text, quote, extraordinary delegation of Congress powers, right? And then they reference the West Virginia versus the EPA 597. They go into further quotations, quoting the Utility Air Regulatory Group, right, versus the EPA. So these sections right here are more like citations, because that's going to happen a lot when you read these kind of things. In several cases described as involving major questions, quote, the court has reasoned that both separation of power principles and the practical understanding of legislative intent, end quote, suggest Congress would not have delegated, quote, highly consequential power, end quote, through ambiguous language. Let's see. So I tried to cheat the system with this highlighting. Okay. I feel like we want that smaller. Looking for the word not. Okay. I really want to at least highlight that when we come back and look at it, right? Okay, so these considerations apply with particular force, whereas here the purported delegation involves the core congressional power of the purse. Congressional practice confirms when Congress has delegated its tariff powers, it has done so in explicit terms and subject to strict limitations. So we see that part right there, and they wouldn't do it with all this ambiguous language where we don't know what's happening. It'd be done so in explicit terms and subject to strict limitations. We might not need to highlight that part, but I do feel like it is significant. So explicit terms and subject to strict limitations. So against that backdrop of clear and limited delegation, the government reads IEEPA to give the president power to unilaterally impose unbounded tariffs and change them right against that. That view would represent a transformative expansion of the president's authority over tariff policy. It is also telling that the IEEPA's half-century, the president has invoked the statute to impose any tariffs, let alone tariffs of this magnitude and scope. That, quote, lack of historical precedent, end quote, coupled with the breadth of authority, end quote, that the president now claims suggests that the tariffs exceed beyond the president's, quote, legitimate reach, end quote. It looks like they reference the National Federation of Independent Business versus OSHA. The economic and political significance, end quote, of the authority the president has asserted likewise provides a reason to hesitate before concluding that Congress meant to confer such authority. West Virginia, 597 U.S., and it quotes the FDA versus the Brown versus the Williamson Tobacco Company, specifically referencing in that citation there. The stakes here dwarf those of other major questions cases, right? And as in those cases, quote, a reasonable interpreter would not expect, end quote, Congress to pawn such a big-time policy call off to another branch, right? And this is Biden versus Nebraska. And then this is where Barrett J. concurred. Okay, so it's another justice. There is no such expectation to the major questions doctrine for emergency statutes, nor does the fact that tariffs implicate foreign affairs render the doctrine inapplicable. The farmers gave, quote, Congress alone, end quote, the power to impose tariffs during peacetime, Merritt versus Welsh. And the foreign affair implicated of tariffs do not make it any more likely that Congress would relinquish its tariff power through vague language or without careful limits. Accordingly, the president must, quote, point to clear authorization to justify. His extraordinary exertion of that power, Nebraska. Need to get down, look at it. Okay, 1 second. Ready? 1, 2, 3. Yay. Okay, my apologies. Okay, so it says Nebraska. He cannot. The internal question marks omitted. He cannot. The Chief Justice delivered the opinion of the court with respect to Part 2B, concluding, A, IEEPA authorizes the president to investigate, right? Quote, investigate, block during the pendency of an investigation, regulate, direct, and compel, nullify, void, prevent, or prohibit importation or exportation. Absent from this lengthy list of specific powers is any mention of tariffs or duties. Absent from this lengthy list of specific powers is any mention of tariffs or duties. Had Congress intended to convey this distinct and extraordinary power to impose tariffs, it would have done so expressly as it consistently has in any other tariff statute. So consistently has in any other tariff statute. The power to, quote, regulate importation, end quote, does not fill that void. The term regulate, as ordinarily used, means to fix, quote, fix, establish, or control, to adjust by rule, method, or establish mode, to direct by rule or restriction, to subject to governing principles or law, end quote. Black Law Dictionary, 1156. The facial breadth of this definition places its stark relief. What regulate, or rather, quote, regulate, is not usually thought to include taxation. Many statutes grant the executive the power to, quote, regulate, end quote. Yet the government cannot identify any statute in which the power to regulate includes the power to tax. The court is therefore skeptical that in IEEPA and IEEPA alone, Congress hid a delegation of its birthright power to tax within the quoted power to regulate, right? So they get into these receipts, right? while taxes may accomplish regulatory end, it does not follow that power to regulate. The power to regulate includes the power to tax as a means of regulation. Interesting. While taxes may accomplish regulatory ends, it does not follow that the power to regulate includes the power to tax as a means of regulation. Indeed, when Congress addresses both the power to regulate and to tax, when Congress addresses the power to regulate and the power to tax, it does so separately and expressly. That it does not do so here is strong evidence that, quote, regulate, end quote, in IEEP does not include taxation. Well, a contrary reading would render IEEPA partly unconstitutional. IEEPA authorizes the president to, quote, regulate importation or exportation, end quote. But taxing exports is expressly forbidden by the Constitution. Let's make a note here, right? Because what we getting into these receipts. Okay, the neighboring words. The quote, neighboring words, end quote, with which regulate, end quote, is associated, also suggests that Congress did not intend for, quote, regulate, end quote, to include the revenue raising powers, referencing United States versus Williams. Each of the 9 verbs in authorizes a distinct action a president may take foreign actors or controlling domestic actors engaged in foreign commerce as president or as presidential practice confirms. I'm gonna move down a little bit because we're almost done. So, as presidential practice confirms, and none of the listed authorities include the distinct and extraordinary power to raise revenue, a power which no president has ever had in IEEPA. Okay, wait a minute, because we getting into these receipts. They said and just for giggles, I want to add a little highlight. Okay. Right? Because very distinctly, I think that's very salient right there. We get into the meat. Getting to the meat on these bones. I'm going to go back and read that section just one more time. The neighboring words with which regulate is associated also suggest that Congress did not intend for regulate to include the revenue raising power, right? Referencing United States versus Williams. Each of the 9 verbs in authorize a distinct action a president might take in sanctioning foreign actors or controlling domestic actors engaged in foreign commerce, as presidential practice confirms. And none of the listed authorities include the distinct and extraordinary power to raise revenue, a power which no president has ever found in IEEPA. They cited page 14 through 16. Okay. So B, several arguments marshaled in response are unpersuasive. First, the contention that IEEPA confers the power to impose tariffs because early commentators and the court cases discuss tariffs in, let's see, the context of the wrong question. Answers the wrong question. The question is not whether tariffs can ever be a means of regulating commerce. It is instead whether Congress, when I'm just put this thing on pause. I'm tired of hearing it. My apologies, y'all. So it is instead whether Congress, while conferring the power to regulate importation, gave the president the power to impose tariffs at his sole discretion. And Congress's pattern of usage is plain. And Congress' pattern of usage is plain. When Congress grants the power to impose tariffs, it does so clearly and with careful constraints. It did neither in IEEPA. Okay, listen, they get into these receipts. They said, whatever question you said, they said, boom, that was the wrong question. They gave the appropriate question, said, this answers. I loved it, right? I love the fact that we're getting so much information. So second, the argument that regulate naturally includes tariffs because the term lies between two poles in IEEPA, quote, compel on the affirmative end and, quote, prohibit on the negative end is unavailable or unavailing. Although tariffs may be less extreme than an outright compulsion or prohibition, it does not follow that tariffs lie on the spectrum between those poles. They are different in kind, not degree, from other authorities in IEEPA. Tariffs operate directly on domestic importers to raise revenue for the Treasury and are very clearly a branch of the taxing power. This is Gibson. Case that they're referencing here. Thus, they fall outside the spectrum entirely. Third, was Treasury mark. Okay. The third, the argument based on IEEPA's predecessor, the Trading with the Enemy Act, TWEA, the Trading with the Enemy Act, and the Court of Customs and Patent Appeals decision in United States Shida International Incorporated. Move this up. Cannot bear the weight placed on it. A single expressly limited opinion from a specialized intermediate appellate court does not establish a well-settled meaning that the court can assume Congress incorporated into IEEPA. So how I interpret that is they saying that's a stretch. Fourth, the historical argument based on the court's wartime presidents fails. Those presidents are facially inopposite, as all agree the president lacks inherent peacetime authority to impose tariffs, and the attenuate chain of inferences from wartime presidents through multiple iterations of the TWEA to IEEPA cannot support, much less clearly support, a reading of IEEPA that includes the distinct power to impose tariffs. Finally, okay, we getting there, y'all. Finally, arguments relying on this court's president lack merit. Federal Energy Administration versus the Algonquin SNG Incorporated bears little on the meaning of IEEPA, right? They talk about the sections of the Trade Expansion Act of 1962 contains sweeping discretion conferring language that IEEPA does not contain, and the explicit reference to duties in sections 232A renders it natural for sections 232B itself to authorize duties, nor does Dames and Moore versus Reagan offer support because that case was exceedingly narrow, did not address the president's power to regulate, and did not involve tariffs at all. That was page 16 through 20. So Justice Kagan, joined by Justice Sotomayor and Justice Jackson, agreed that IEEPA does not authorize the president to impose tariffs, but concludes that the court needs not invoke the major questions doctrine because the ordinary tool of statutory interpretation amply supports that result, page 1 through 7. So Justice Jackson would also consult legislative history, and particularly the House and the Census report that accompanied the IEEPA and its predecessor statute, TWEA, to determine that Congress did not intend for IEEPA to authorize the executive to impose tariffs. Okay, Robert C.J. announced the judgment of the court and delivered the opinion of the court with respect to parts 1, 2, parts 1 and part 2A1 and part 2, which, they joined in with respect to part 2. And they were concurring and offering opinions. You all have seen the reading of the syllabus. We made it through page 6. Anything after that will be jumping directly into the opinion. So that means you'll be looking at roughly 163 more pages. And I would welcome you to look into that. But look at that, you guys. We were able to read 6 pages, which is the opinion here. So as you go out and you see the articles, feel informed that you have at least looked at the summary of their findings and feel empowered by because, child, we are getting into these receipts, and I read y'all that whole little setup. I am so excited to have been with you this early afternoon. I wanted to be able to do this during the lunch period because I know all these articles are out. And I'm like, listen, let's get to these receipts. Let's just go ahead and read it. Let's see what they said, right? They gave us a lot of citations. They gave us a lot of information. They said, okay, y'all answered the question. It was the wrong question. They said, I think that's a reach with one part. I mean, I loved how they just jumped in like, okay, that was the wrong question. Let's get to the correct question. That was a reach. This is a stretch. This is a stretch. We didn't need to do all the stretching because the documents clearly stated, that certain things were enough, right? We can infer that much, right? Now, I'm not a lawyer. I'm not an attorney. As a matter of fact, I am just an international law student. I'm also a social worker by training, mediator, and all of that. But I just feel like as a genuine constituent, we should be able to sit down, read these documents, and have some clarity and have some understanding on what is happening. Because as they say, right, that takes more money from us. And when we have our money taken, in most cases, we're under the assumption that Congress is handling a lot of those things. We didn't say, a lot of us didn't agree to certain things happening. And I was like, okay, I love that we are able to see some checks and balance happen in real time. Like, hey, sir, that was not supposed to happen. Thank you. Because y'all know we love accountability over here. What? We love accountability. So I'm so happy to see. I'm excited about the news that I've been reporting this week, right? Because we've been talking a lot about accountability. I love that we were able to see their rule in real time. It came out today, was posted today. So as y'all seeing these articles, feel free to just pop on back over here, get the real, right? And additionally, I want you all to know that I'll be taking this article, the link to the article, and I'll be putting it over into the community space so that you can go peruse through that 170-page document on your own, but just feel informed that you have some information. You did get to hear at least a summary. I offered a little bit of explaining here and there as I could. But we in this together. Look, we're all in this together. I don't know if y'all remember that. I'm dating myself as a millennial, but for real, we really are all in this together. And I want us also to be able to share information, communications, because it's all about civic learning. It's all about civic literacy. We have midterms coming up, right? And we need people to be very informed so that when you go out there, you're able to do what you need to do. There are so many seats that are up. The conversation of democracy is getting really exciting right now because you have so many seats that are up, right? We have so many seats that are up. So at times like this, I just really want the community to be informed. And this is all publicly accessible information. So stay tuned. I look forward to speaking to you more. And what we getting into these receipts, you can't say to come to see. I gave y'all the whole receipt on the screen. Once again, this is Adrienne from Legally Everywhere, where we looking into everything. And what's that? Not a receipt? The whole summary? I don't know how many times I'll be sitting there reading the whole summary for y'all, child. But I had to look back and see how I'm looking on this camera because I had to be all up in the camera like this trying to read the screen. But I want you all to have that receipt, okay? Because, right? I'll see you guys next time. We will likely have another live today. So stay tuned. Hopefully we're all able to enjoy your lunch break, because this is generally during that time. If you're catching this later in the day, I'm still excited that you were able to drop by. See you in the next video. Bye.